My father used to say that land remembers everything. He said it the way ranchers say things, not as philosophy, but as fact. He had worked the same 640 acres in Douglas County for 41 years, and he knew every fence line, every drainage channel, every rise and hollow the way most people know the layout of their own house. He walked the perimeter of his property twice a year, every year, on the first Saturday of April and the first Saturday of October. He called it reading the land. He said land that isn't watched will find ways to tell you what it needs. He died in November of 2014. He was 81 years old, and he died in the house he had built in 1973, and he left me everything. The house, the outbuildings, the cattle operation, and 640 acres of Colorado grassland that had been in our family since my grandfather homesteaded it in 1938. He also left me, though neither of us knew it at the time, 7 years of evidence. By the time my father died, a man named Craig Delworth had already been using 40 acres of our land for 14 months. He had cut a road through the northeast corner of our property. He had buried utility lines across 2 pastures without asking permission and without paying for the right to do so. He had sold access to that road to 3 separate residential developers who were building subdivisions on the land to the east. He had done all of this quietly, methodically, while my father was in his final decline and I was driving back and forth between Denver and the ranch trying to manage both. When I finally found out, not because Craig told me, but because a satellite showed me what he had done, he had been using my land for 7 years. He thought I would never find out. He was wrong about that. He was wrong about several things. My name is Sandra Whitfield. I am 69 years old, and I live between Denver and the ranch in Douglas County, Colorado, where my family has run a cattle operation for 3 generations. I am not an attorney, and I am not a developer, and I did not grow up thinking I would ever spend 18 months in litigation over a property boundary. I grew up thinking I would raise cattle, which I still do, and that the land my grandfather homesteaded would pass to my children the way it passed to me, intact, documented, and free of anyone else's roads. That is still what will happen. The land is intact. The documentation is correct. And Craig Delworth paid me $290,000 for 7 years of using property that was never his to use. If you are watching this for the first time, please subscribe and leave a comment telling me where you are from. I have heard from more ranchers and landowners than I expected when I started telling this story, and their messages have meant a great deal to me. Now let me tell you about my father's land and what a developer from Castle Rock thought he could do with it while no one was watching. My grandfather, Earl Whitfield, came to Douglas County from Kansas in 1936 with his wife, 2 children, and enough money to purchase a used truck and a one-way bus ticket if the truck broke down. He worked for 3 years on a neighboring operation before he saved enough to file on a homestead claim of his own. The land he claimed was not the best land in the county. It was dry, exposed, and had been passed over by earlier settlers for exactly those reasons. But Earl was a patient man, and he understood something about land that impatient people often miss. What looks like poor land is often land that simply requires someone willing to work with it rather than against it. He drilled 2 wells, he built windbreaks, he planted native grasses in the sections that had been overgrazed by previous users and left them alone for 3 years to recover. By 1945, he was running 200 head of cattle on land that other men had looked at and walked away from. My father, Dale, inherited the operation in 1971 when Earl died. Dale was 38 years old, already married to my mother Ruth, and he had grown up on that land the way children grow up on land when there is nowhere else to be, completely, without any sense that another life might have been possible. He expanded the herd. He modernized the equipment carefully, never borrowing more than he could repay in a single good year. He added 2 parcels to the original homestead claim through purchases in 1978 and 1989, bringing the total to 640 acres. He was, by any measure, an excellent steward of what his father had built. I was his only child. My mother died when I was 12, and after that it was Dale and me and the land and the cattle and the particular quiet of a ranch in Douglas County in the 1960s and 1970s, which was a different kind of quiet than you find there now. Douglas County is one of the fastest-growing counties in Colorado. The grassland that bordered our property to the east, land that had been ranched by a family named Pierce for 2 generations, was sold in 2008 to a residential development company based in Castle Rock. The company was called Summit Ridge Properties. Its principal owner was Craig Delworth. I knew Craig by sight and by reputation. He was in his mid-50s, a compact, energetic man who had made a considerable amount of money in the Colorado residential development boom of the 2000s. He was not someone I had any particular feeling about. He was a neighbor in the way that people who own adjacent land are neighbors, which in Douglas County means you know their name and you have waved at their truck on the county road, and that is the extent of it. When Craig bought the Pierce property in 2008, he sent me a letter introducing himself as the new owner and expressing interest in maintaining good relations with adjacent landowners. It was a professional letter, the kind that a lawyer had probably helped draft. I wrote back a brief note welcoming him to the area. That was the last direct communication I had with Craig Delworth for 6 years. In those 6 years, my father's health declined. The decline was gradual at first, the normal slowing of a man in his late 70s, and then, in 2012, accelerating. By 2013, he had been diagnosed with vascular dementia and required increasing assistance with daily life. I was living in Denver, where I had built a career as a civil engineer and raised 2 children with my husband Tom, and I was commuting to the ranch on weekends and managing his care during the week by phone. My father could no longer walk the perimeter. He could no longer read the land. Craig Delworth knew this. I am certain of it, though I cannot prove the specific moment he understood that no one was watching the northeast corner of our property. What I can prove, what the satellite images prove with timestamps, is that he began using it in September of 2013, 13 months before my father died. The first sign came in the spring of 2015, 5 months after my father died. I was at the ranch on a Saturday in April, the first April without Dale, which had its own particular weight. And I was doing what he had always done on the first Saturday of April, walking the perimeter, reading the land the way he had taught me. I had not walked the full perimeter in 2 years. The northeast corner was the farthest point from the house, a 40-minute walk across open pasture, and during the years of my father's decline, I had been at the ranch to manage his care rather than to inspect fence lines. I told myself I would get to it. I did not get to it. When I reached the northeast corner that April morning, I found a gate. Not our gate. A steel tube gate, commercial grade, set into our fence line on new posts that had been driven into our soil. The fence on either side of the gate was our fence, our wire, our original posts, some of them going back to my grandfather's time. But the gate was new, and it was padlocked, and I did not have the key. I stood at that gate for a long time. On the other side of the gate, running northeast across what was clearly our land based on the fence line I was standing at, was a graded dirt road. It was not a rough track. It was a properly graded road, perhaps 12 feet wide, with drainage ditches on both sides and gravel laid in the low sections. It had been there long enough that grass had begun to grow back along the edges. I photographed it with my phone. I photographed the gate and the posts and the lock. I walked along our fence line as far as I could see in both directions, looking for where the road had entered our property. The fence had been cut and restrung approximately 60 yards to the south of the gate. You could see it if you knew what to look for. The wire slightly newer, the tension slightly different from the original. I drove to Craig Delworth's development office in Castle Rock that afternoon. He wasn't there. His office manager, a young woman who seemed genuinely uncomfortable when I explained why I was there, told me Mr. Delworth was on site and gave me a number to call. I called the number from the parking lot. Craig answered on the third ring. I told him there was a road on my property and a gate in my fence, and I wanted to know how they had gotten there. He said, and I remember this very precisely because I wrote it down when I got back to my truck. __, quote, _0, __. I said, __, quote, _1, __. He said he was sure there was some confusion and that he would have his attorney reach out to clarify the situation. His attorney did not reach out. I drove home to Denver that evening and called Tom, who listened without interrupting and then said, __, quote, _2, __. I called a land attorney Monday morning. Her name was Patricia Oakes, and she had been handling property disputes in Douglas County for 22 years. When I described what I had found, she asked 2 questions. Did I have a current survey of the property, and did I have photographs? I had both. She said, quote, 3. What Patricia found in the county records over the following 2 weeks was the second warning sign, and it was considerably larger than the first. Craig Delworth had filed, in October of 2013, an application for a construction access permit with Douglas County Roads and Bridges. The application described a temporary construction road to be used for site access during the development of Summit Ridge Estates Phase 2. The application listed the road's location as traversing a portion of an unnamed parcel adjacent to the Summit Ridge property's holdings. The unnamed parcel was our land. The application had been approved by the county because county applications for construction access permits are reviewed for engineering adequacy, drainage, width, surface treatment, not for the applicant's legal right to build on the land in question. The county had assumed that a developer filing for a permit had the legal authority to build where he was proposing to build. No one had checked. Craig had used a county permit to give his road an official-looking paper trail, while never establishing any legal right to cross our property. Patricia pulled the permit file. The application contained a site plan. The site plan showed the road crossing our parcel. In the box on the application where the applicant was required to certify that he had the legal right to use the described land, Craig had checked the box marked __, quote, _4, __. He had not obtained our consent. My father had been showing early signs of dementia in October of 2013 and would not have understood what he was signing. Craig had checked the box anyway. The third warning sign came when Patricia ordered a title search and discovered that Craig had, in January of 2015, 2 months after my father's death and 4 months before I found the gate, quietly approached the county assessor's office to inquire about the process for establishing a prescriptive easement on a neighboring property. A prescriptive easement is a legal mechanism by which a party who has openly and continuously used another person's land for a statutory period, in Colorado, 18 years, can claim a legal right to continue that use. Craig had been using our land since September of 2013. In January of 2015, he had 16 months of use. He needed 18 years. He had been planning to keep using our land for another 16 and a half years, and then claim he had the legal right to do so permanently. Patricia told me this on a Friday afternoon. I was sitting in her office in Castle Rock. I remember the afternoon light coming through the blinds and the sound of traffic on the street outside, and the very specific quality of the anger I felt. Not hot, not immediate, but cold and structural. The kind of anger that feels less like emotion and more like load-bearing material. I said, "What do we need to prove our case?" Patricia said, "We need to establish exactly what he built, exactly when he built it, and exactly what he earned from it. The when is going to be the most important piece." I said, "I know how to find the when." I had spent 30 years as a civil engineer. I knew how infrastructure projects were documented. I knew how satellite imagery worked. And I knew that Google Earth had been archiving aerial photography of the continental United States since 2004. I went home that evening and I opened Google Earth. The historical imagery function in Google Earth allows you to scroll backward through archived satellite photographs of a specific location, month by month in some cases, going back as far as the archive extends. I pulled up the northeast corner of our property. I went back to 2008, the year Craig bought the Pierce land. Nothing. Undisturbed pasture, our fence line intact, no road. I moved forward year by year. 2009, 2010, 2011, 2012. Nothing. September of 2013. The road was there. Not fully formed. In the September 2013 image, it was a raw cut, recently graded, the soil still dark and disturbed. But it was there, crossing our fence line at the exact point where I had later found the restrung wire, running northeast toward the Pierce parcel in a straight line that had clearly been engineered rather than worn by casual use. I went forward from September 2013. October, November, December. The road developed. Gravel appeared in the low sections. The drainage ditches were cut. By spring of 2014, it looked exactly as I had found it in April of 2015, except newer. I kept going. 2015, 2016, 2017, 2018, 2019, 2020. The road was in continuous use for the entire period. In several images, I could see tire tracks, equipment staging areas, what appeared to be a temporary utility trench running parallel to the road for approximately 300 yards before crossing back onto the Pierce parcel. In a 2017 image, I could see 3 separate construction sites to the east, all of which appeared to be accessing the road through what had become a well-established junction point on our property. I printed 47 images with their date stamps. I drove to Patricia's office the next morning and put them on her desk in chronological order. She looked through them without speaking. Then she looked up and said, "Quote 8. I said, "Quote 9. She said, "Quote 10. I said, "Quote 11. Patricia filed suit in Douglas County District Court 4 weeks later. The complaint alleged trespass, unauthorized use of property, unjust enrichment, and interference with property rights. It sought injunctive relief, meaning an immediate court order requiring Craig to cease all use of our property, plus compensatory damages for 7 years of unauthorized use and disgorgement of profits he had made by selling access to our land. Craig's attorneys filed a motion to dismiss, arguing that the use had been inadvertent and that Craig had believed, in good faith, that he had obtained the necessary permissions through the county permit process. Patricia's response to this argument was to attach the county permit application with Craig's signature on the certification box, the box where he had certified that owner consent had been obtained. The judge denied the motion to dismiss. Craig's attorneys then filed a motion arguing that any damages should be limited to the nominal fair market rental value of the land, essentially, what we would have charged for a legitimate easement. Patricia countered that this standard did not account for the profits Craig had made by selling access to the road, and that under Colorado law, a party who is unjustly enriched through trespass can be required to disgorge those profits regardless of whether the property owner would have earned them otherwise. Discovery began in the fall of 2021. Patricia subpoenaed Craig's business records, contracts with the 3 development companies that had used the road, payment records, correspondence. What came back was more than I had expected. Craig had not merely sold access to the road. He had executed formal access agreements with 3 separate residential developers, charging fees that ranged from $18,000 to $47,000 per year per developer, depending on the volume of traffic and the duration of the construction phase. He had marketed the road as a private infrastructure asset in correspondence with potential partners. Over 7 years, Craig Delworth had collected approximately $340,000 in access fees from developers using a road he had built on land he did not own, did not have an easement across, and had never paid $1 to use. Patricia called me when she finished reviewing the documents. She said, "He built a toll road on your property and charged other people to use it." I said, "Yes, that is what he did." She said, "The disgorgement claim just got a lot stronger." I thought about my grandfather Earl, who had drilled wells in dry ground and planted grass and waited 3 years for the land to recover. I thought about my father Dale, who had walked this perimeter twice a year for 41 years and knew every inch of it. I thought about the September of 2013, when Craig had cut through our fence line for the first time while my father was in decline, and I was too consumed with his care to walk to the northeast corner and see what was happening. I thought about the gate with the padlock and the key I did not have. I said, "Let's finish this." The case went to mediation in February of 2022, 14 months after Patricia filed the complaint. Craig's attorneys had, by that point, cycled through 3 separate legal strategies. The first, that the use was inadvertent and based on a good-faith misunderstanding of the permitting process, had failed against the permit application with Craig's own signature on the consent certification. The second, that damages should be limited to nominal rental value, had weakened considerably when the discovery documents revealed the access fee contracts. The third strategy, which emerged in the months before mediation, was to argue that our damages claim was overstated because some portion of the road's value had derived from Craig's investment in constructing and maintaining it, not merely from the underlying land. Patricia found this argument interesting in the way that experienced attorneys find arguments interesting when they know exactly how to dismantle them. She said, "He wants credit for the cost of building the road he built illegally on your property." We'll let the mediator hear that one. The mediator was a retired district court judge named Warren Haas, who had spent 12 years handling complex property disputes before moving to private practice. He was in his late 60s, unhurried, and had the quality I have observed in the best judges: the ability to absorb the essential facts of a situation quickly and then ask the one question that everyone in the room has been avoiding. In this case, the question came in the first session, directed at Craig's lead attorney. Judge Haas said, Craig's attorney said the certification had referred to a verbal understanding that Craig believed he had with Dale Whitfield prior to Dale's decline. Judge Haas looked at the attorney for a moment. Then he looked at Craig. Then he wrote something on his notepad and said, __, quote, _19, __. During the break, Patricia and I sat in a small room, and she told me that Craig's verbal understanding argument was, in her professional assessment, not going to survive the afternoon. A verbal easement agreement for a commercial road across agricultural land, unsupported by any documentation, executed with a man who was subsequently diagnosed with dementia. A Colorado court was not going to find that persuasive. She was right. When we returned to the mediation room, Craig's attorneys presented a revised position. They acknowledged that the permitting process had been improperly completed and that the road had been built without formal legal authorization. They proposed a settlement that included removal of the road at Craig's expense, restoration of the fence line to its original condition, and a cash payment to resolve all claims. Their opening number was $140,000. Patricia did not blink. She said our documented damages, 7 years of access fees collected from 3 developers, plus the cost of fence restoration, plus compensation for the agricultural use of the land that had been disrupted by the road's presence, totaled $418,000, and that we were prepared to proceed to trial if the settlement did not reflect the actual scope of what had occurred. Craig's attorneys asked for a recess to consult with their client. The recess lasted 40 minutes. I sat in the small room and drank bad coffee and thought about my father walking this perimeter in October, year after year, knowing every inch of it. I thought about the northeast corner that I had not walked for 2 years while I was managing his decline. I thought about Craig in September of 2013, cutting our fence and driving his equipment onto our land for the first time, looking around at the undisturbed pasture and deciding that no one was watching. Craig's attorneys came back with $230,000. Patricia countered at $360,000. They went back and forth through the afternoon and into the early evening. Judge Haas moved between the rooms with the patience of someone who has done this many times and understands that the number will eventually find its place. At 7:40 in the evening, Craig Delworth agreed to pay $290,000 in full settlement of all claims. The settlement also required him to remove the road and all associated infrastructure from our property within 90 days at his own expense, and to restore the fence line to its original condition using materials and specifications that Patricia had negotiated into the agreement. It further required him to provide written notice to the 3 development companies that had used the road that their access agreements were void, and to cooperate with any claims those companies might subsequently bring against him for the access fees they had paid for use of land he did not control. I shook Judge Haas's hand when it was done. He said, with the mild understatement of a man who has seen a great deal of property litigation, "You had strong facts." I said, "My father taught me to read the land." He looked at me for a moment and then nodded, as if he understood exactly what I meant. The road was removed in June of 2022. Craig's contractors worked for 11 days dismantling the gravel surface, filling the drainage ditches, removing the utility infrastructure. I was at the ranch for the last 2 days of the work. I watched them pull the gate out of the fence line, the padlocked gate that I had found on that April morning in 2015, and load it onto a flatbed truck. The fence was restrung with new wire and new posts where the old ones had been cut and replaced. When it was done, I walked that section of fence line from one end to the other, running my hand along the wire the way my father used to do. The land was ours again. It had always been ours. But there is a difference between something being true and something being restored, and the restoration mattered in a way I had not fully anticipated until I stood there with my hand on the wire and felt it. The settlement check cleared in July of 2022. I deposited half of it into an account I have set aside for my children's eventual inheritance of the ranch. The other half went into operational improvements that my father had deferred during his final years: water infrastructure, fencing in the southern sections, equipment that had been held together with ingenuity and determination for longer than was strictly advisable. The northeast corner is grass again. Native grass, the kind my grandfather planted 70 years ago when he decided to work with the land rather than against it. My father said land remembers everything. I believe this is true in a practical sense as well as a philosophical one. The satellite record of what Craig Delworth did to our property exists because cameras in orbit photographed it, month after month, without anyone asking them to. The timestamps are precise. The images are clear. A road that was built illegally in September of 2013 is visible in September of 2013, and it is visible in every subsequent year until it was removed in June of 2022. The land recorded what happened to it, and when the time came, that record was sufficient. I want to tell you 3 practical things that I learned from this experience, because this story is not only about what Craig did, it is about what I did and did not do that made it possible for him to do it for 7 years. The first thing is this: walk your land. If you own property, any property, not only agricultural land, inspect it. Physically, in person, on a regular schedule. Look at the boundaries. Look at the fence lines. Look for anything that was not there the last time you looked. My father walked his perimeter twice a year for 41 years. When I stopped doing this during his decline, Craig had an opening that he used. The second thing: satellite imagery is free and it is powerful, and most property owners do not know how to use it. Google Earth's historical imagery function is available to anyone with an internet connection. If you suspect that something has changed on your property, or if you simply want to establish a baseline record of its condition, pull the historical images. Download them with their timestamps. Keep them. They cost nothing, and they prove 7 years of trespass, in my case, more conclusively than any witness testimony could have. The third thing is about what happens when someone tells you there has been a misunderstanding. Craig's first response when I called him from the parking lot of his office was to tell me there was some confusion and that he would have his attorney reach out. This is a specific kind of response: calm, professional, slightly condescending, designed to make you feel that you are the one who doesn't understand the situation. It is a response that is most effective against people who are uncertain of their facts. I was not uncertain of my facts. I had photographs, I had a survey, I had a land attorney on the phone by Monday morning. If someone tells you there has been a misunderstanding about your property, treat it as what it may be: an attempt to buy time while they assess their exposure. Document what you have seen. Secure the evidence. Call an attorney before you have another conversation with the other party. The land is still ours. 640 acres in Douglas County, Colorado. The same land my grandfather claimed in 1938. The same land my father walked twice a year for 41 years. The same land I will pass to my children when the time comes. The northeast corner is grass. The fence is straight. The gate with the padlock is gone. I walk the perimeter now on the first Saturday of April and the first Saturday of October. My father taught me that. It turned out to be the most important thing he taught me. Tell me where you are watching from today. And if you own land, any land, go walk it this weekend. Look at the corners. Look at the fence lines. Look at what is there and what is not there. The land will tell you what you need to know. Thank you for being here. Sandra Whitfield, Denver, Colorado.